The second lecture on the series relating to legal profession is relating to legal ethics and professional conduct. So, what exactly legal ethics means? As the central function of the legal profession is to promote the administration of justice, and it is a noble profession. Besides, it is also an elitist profession. Its ethics in practice leave much to be desired if viewed as a profession for the people. Law's nobility as a profession lasts only so long as the members maintain their commitment to integrity and service to the community. If the practice of law is thus a public utility of great implication, it obliges the lawyer to observe those norms which make him worthy of the confidence of the community in him as a vehicle of justice, which is otherwise called social justice. The profession of lawyers maintains a high level of ethics as much as in the means as in the ends. In the very conference on judicial ethics at the School of Law, University of Chicago, Professor John Hastings opined that it must be a conscience alive to the proprieties and the improprieties incident to the discharge of a sacred public trust, governed by the rejection of self-interest and self-ambition to play a leading role in the fair and impartial administration of justice, to the end that public confidence may be kept undiminished at all times in the belief that we shall always seek truth and justice in the preservation of the rule of law. The above observation will be better understood if we critically analyze the rules framed by the Bar Council of India with reference to the Advocates Act 1961 under Chapter 2 of Part 6. The said chapter deals with the nature and meaning of professional ethics under four distinguished sections, and these sections are as relating to section 1 duty to courts consist that 10 different rules from rule 1 to 10, and advocate during presentation of his case or acting before a court shall conduct himself with dignity and self-respect, maintain a respectful attitude towards the court, shall not influence the decision of a court, shall restrain and prevent his client from adopting unfair practices and improper conduct, shall practice and improper conduct, and shall appear in the prescribed dress, shall not act or plead before a court if the presiding judge or any of its members related to him, and shall not wear bands or gowns in public places, shall not appear for or against an organization if he is a member of the executive committee of that organization, shall not act or plead in any matter in which he is pecuniarily interested, and lastly, he should not act as a surety for his client required for the purpose of any legal proceedings, and Section 2 of the Bar Council rules under the Advocates Act 1961 is relating to duty to client, which comprised from Rule 11 to Rule 33. And under the very rules, an advocate is bound to accept any brief at a free consistent with his standing and the nature of the case. Any refusal may be with special circumstances and without reasonable and sufficient cause he shall not withdraw from a case once accepted, shall not accept a brief or appear in a case if he will be a witness in the proceedings of the case. So also before accepting any brief he must be frank and open to his client if he has any connection and interest with the parties. Further, he should fearlessly uphold the interest of his client. He shall not be a party to fermenting of litigation, except his client. He shall not take instruction from any other person, shall not stipulate for a fee or share in the proceeds or results of the litigation. When he is professionally engaged in any suit, should not bid for purchase of any property sold in the execution of the decree or order. He should not adjust his personal liability to the client from the fees paid by the client. He should maintain an account of the client's money paid to him, as Rule 25 to Rule 32 widely covers the duties of an advocate towards his client's money through a proper maintenance of account. Rule 33 prohibits an advocate on the ground that if ever he advised, appealed, or has drawn pleadings for a party, should not act or plead for the opposite party. And the very third section relates to duty to opponent. And in regards to that, it covers Rule 34 and 35 of the Bar Council of India rules in connection to Advocates Act 1961. He is prohibited to communicate or negotiate upon the subject matter of the case with the opponent and shall do his best to carry out all legitimate promises made to the opposite party. And finally, Section 4 provides regarding duty to colleagues, which explained under the Rule 36 to Rule 39, where he is strictly prohibited to advertise and publication of any success of his cases or achievements. So also he is restricted using circulars, touts, and personal communication for his advertisements. He is further bad to permit the use of his professional service by any agency. Lastly, he should not act or appear in a case for which already a wakalat or memo of appearance is filed by another advocate unless and until such consent is given by the said advocate. So these are the obligations thrust upon as duties under Rule 1 to Rule 39 discussed above are the canons of professional conduct and etiquette to enable an advocate to project himself in a manner befitting his status as an officer of the court, a privileged member of the community and a gentleman, and his conduct should conform to the rules analyzed both in letter and spirit. It is in accordance with professional ethics or legal ethics. The relation between a lawyer and his client is highly fiduciary in its nature, in character, requiring and why a very dictated and confidential in character, requiring a high degree of integrity and good faith. A lawyer, when entrusted with a brief, is expected to follow the norms of professional ethics and try to protect the interests of his client in relation to whom he occupies a position of trust. And in that connection, we would like to discuss the very observation made by Professor Upendra Baxi in his article, The Pathology of the Indian Legal Profession at the Present Day. The pathology of the present day legal profession in India, where learned professions are of distinguished from occupations and business. Why their mere virtue of greater integrity and commitment to certain basic social values, lawyers as a professionals are thus oriented to achievement of conditions of justice in society. However, all is not gold that glitters. The responsibility that the Indian bar bears to the society and the challenge that it faces today, we are a testimony that the Indian bar has not risen to the occasion to discharge its duties. So, Professor Upendra Baxi, in his article, The Pathology of the Indian Legal Profession, examines the rules enumerated for professional ethics under the Advocates Act 1961, points out a number of drawbacks and lacunas. The rules give an impression that they are mandatory and productive of disciplinary consequences, but looking to the fees charged, fermentation of litigations, whenever chances occur, lack of professional norms, the behavior pattern of the legal community, and confusing the meaning of professional misconduct expose the community to a severe commentation of the society. The obligation to provide free legal aid are being refused by affluent superstar lawyers is against the dignity of the profession. The profession is becoming dynastic in character and content. So he questioned in what does the characters of the profession lie? Learning, integrity, dictation to the fundamental duties, legal services to improvised or fighting against social injustice, measured by any one of these or all of it is quite unfortunate and marks the low level to which the profession has declined so as to make it an occupation or business. So, He suggests that the Advocates Act needs to be fundamentally amended to acquire a character of a learned profession. So, to conclude, in the words of Professor Upendra Baxi, the future of the legal profession lies in its ability to take it seriously. This means care and concern not just for independence of the bar and the bench, a vital issue, rather well served with a capacity to struggle regardless of fees for the vast majority of the deprived, disadvantaged, and depressed classes of India. As law is an instrument for social change, it helps the growth of the idea that power must conform to certain ideals of the rule of law, and that power does not justify itself because it is power. So, the very topic relating to legal ethics or professional ethics and professional conduct as provided under the Bar Council of India rules with reference to Advocates Act 1961 that we have discussed in this lecture. Besides that, the present day position of legal profession in India, which is better explained by Professor Upendra Baxi of Delhi University in his article, The Pathology of the Present Day Legal Profession in India. So we have completed the very important lecture on this series, the second lecture relating to legal ethics or professional ethics and professional conduct, which is one of the most integral part of legal profession.